A very good evening to you. I'm Lisa Lord, and my special guest is the Chief Executive Officer of the Fair Trading Commission, Dr. Marcia Atherley Ikechi. Ma'am, thank you so much for finally joining us on the program.
Thank you very much for having me.
You're most welcome. Now, I want to start by looking at the role of the FTC in a nutshell, if you could.
The role of the FTC is largely to do a number of things because we have three different departments. We have consumer protection, which is essentially an entity that is intended to safeguard the interests of consumers, particularly as it relates to the business-consumer type relationship, understanding that there is some asymmetry there or variation in the powers of the two entities, and we want to bring balance to that. So that's one end, consumer protection, and that's governed by the Consumer Protection Act. There is also fair competition that speaks largely to business type transactions, mergers, anti-competitive behavior, those types of things. So that particular division, you would not necessarily see that in the limelight because of it is really business type transactions. Then there's utility regulation, which is in the forefront at the moment because we have a rate case pending. We regulate Barbados Light and Power, Cable and Wireless, and Barbados Water Authority. Those are the specified utilities that are listed in the schedule of services that are regulated.
And I want to stick on utility regulation because Barbadians are eagerly awaiting the outcome of the hearing, which is set to start on August 25th regarding the Barbados Light and Power's application for a rate increase. 8 interveners have been approved to take part in the process. What does a process like this entail? If you could break it down for me.
So the Commission received the application from Light and Power in about October last year, October 2021. On receipt of that application, we had to just digest the information as given. The application is over 1,200 pages with number of appendices. That type of analysis had to take place, but actually prior to that, there is something called the depreciation schedule or depreciation policy that impacts the actual rates at any given time. So the Commission had to go through that study to determine what are the approved depreciation rates that would apply to the rates to the application, substantive application. That was done over a period of time. Coming out of that, we issued that sometime earlier this year, where the Commission approved the depreciation schedule as proposed by the utility for transmission and distribution. The Commission did not approve that for generation. We felt it was not fully substantiated, and therefore we've given the utility an opportunity to go back to the table and see how they can best present a case for that particular area. So that's where we are with the depreciation. So within the general rate application, there is an application for confidentiality. That is for some information contained in the application to be kept confidential away from public scrutiny. And that largely pertains to one, grid outlay, as well as financial information. The financial information that they're asking to be kept confidential largely relates to renewable energy plant that has not been procured as yet. So that is not relevant to the rate case. And therefore, the expectation is that that will not be included. Similarly, as it relates to the grid and the infrastructure, that presents security concerns, and that also will not be offered to the public. So it's an extremely long process. You have to be very detailed, very analytical. The first part of the application then speaks to interim rate relief. The applicant has asked for interim rate relief. And essentially what that means is that they're asking for a rate as they have asked for that rate to be applied on the bills for consumers before we actually make a final determination on the outcome of the substantive rate. They're essentially saying that this will allow them to bolster their financial position to be able to have certain capital outlays implemented. That in and of itself does not, even if that were given, does not mean that the substantive rate that they've applied for will be given. The Commission has a number of options at its disposal. It can either deny the rate altogether, give a partial rate or rate that is part of what they've asked for. They can give fully what they've asked for, or they can give something that is even greater than what they've asked for. Those are the options available to the Commission. What I want to point out, though, is that with interim rate, the caveat is that if there is any change in terms of what is given in the interim relative to what is given at the end of the substantive rate review, those costs to the customers can be recovered. So the customers can, one, benefit from an interest rate on the monies that they would have paid during the interim rate relief period if it is granted. And then if there is a difference, there's a negative difference between what was given and what was granted, then those monies must be reimbursed to the customer.
When the public hearing starts on August 25th, how long do you anticipate the process will last?
We have scheduled 12 days of hearings, face-to-face hearings for that process. But beyond that, even before we get to that point, there is a period where after we did the interim rate relief, that hearing, we did that on July 1st. Then we went to July 4th and we did a procedural and issues conference. That is intended to have, where we have a discussion with the utility as well as interveners to come up with a set of issues that will be pertinent to what we address in the rate. So it narrows the scope a little bit and allows us to focus on the critical issues.
Just to be clear, you mentioned the procedural and issues conference, but what happens after that conference takes place?
Okay. So that conference took place on July 4th. After that, what we will be doing, we'll be inviting interveners to submit their interventions or questions, interrogatories or questions, and that is a back and forth that will take place over the next 4 to 6 weeks, up until just before the actual
hearing.
Formal face-to-face rate hearing. Interveners will pose their questions or interrogatories. The utility will be given an opportunity to respond. If they need clarification from any of the interveners or any of the issues, that is the opportunity to do so. The Commission may also pose questions, and these are all based on the issues that were settled in the procedural and issues conference. Then we will lead into the face-to-face hearing, at which point there will be the interrogation of the applicant by the interveners as well as the Commission. That will be done following the general procedure rules that have already been agreed to. That's expected to take about 12 business days. After that, we will go into the writing of the determination, and that is expected to take between 4 to 6 weeks.
And while you've had rate hearings before, this one is generating particular interest.
Yes. So we are in a very tumultuous time economically. That, to my mind, is probably the most significant driver. We are also in a transition in terms of moving from fossil fuel generation to renewable energy. The outlay of capital resources in terms of infrastructure, that has to take place. But again, the rate application is solely focused on what is used and useful by the entity or is in the process of being used and useful. That is, those projects that are in the process of being commissioned are things that are on the ground being used for the benefit of consumers. It will not take into account projects that are down the line that have not been commissioned, not been planned and approved as yet.
How do you go about giving approval to these interveners?
There's a very low bar for intervener status. You apply, we send out the notice indicating that this is what is being proposed and ask or open for interveners to submit. Essentially what they have to do is indicate an interest, and as a consumer in Barbados, the bar is very low, so therefore you can apply for intervener status.
So it's very simple.
It is simple, but at the same time, once you get into the process, there's a lot of work that is involved. So it is not something that should be taken lightly. It is really a voluntary endeavor, but there's a lot of information that you would need to be able to digest if you're going to contribute meaningfully to the process.
Since we're on the Barbados Light and Power, I want to look at what goes into the composition of electricity bills.
So there are essentially three components of the electricity bill, and that has already been established. They're broken out in the bill as you see them. There's a base rate that speaks to things like the customer charge, things like polls, administrative fees, those types of things. Then there's the fuel clause adjustment. That is the bit that is very volatile at this point in time, given what's happening not only in Barbados but the world over. That is really a full pass-through charge. So whatever the cost of oil is on the international market, whatever the utility pays from BNOCL for the cost of oil, that is passed through. And that is reflected. You can control that by controlling not necessarily the unit price, but you can control that by controlling your consumption of electricity. Really and truly, the utility has no control over that outside as if they were opting to hedge to some extent. And that in and of itself, there's a risk associated with that.
When it comes to utility companies, how does the FTC go about investigating complaints from consumers?
Consumer complaints are assessed first. We have a complaints form, a formal complaints form. Persons will either call in with an issue. Sometimes we can settle it over the telephone. Other times it might escalate into a more formal complaint. There's a complaint form that persons can get over on the website. Once that is completed, we would engage if there's further information that we need to get. But we ask the individuals to first engage the utility, give them 12 business days in which to respond, or 14 business days, I'm sorry. If they don't respond within that time period, they can come to us with any supporting information that they might have, correspondence or whatever, bills, whatever they have. And this goes for all the utilities. Once that is done, we will assess based on the information provided and engaging utility as well. They're required to provide certain reports, and an assessment is done based on that. And we revert to the parties.
And why I asked, when it comes to utility companies, sometimes you have a situation where a consumer might be without a service for a day, even weeks. The bill comes out the exact same way as it did months before, with no compensation.
So we have a set of guaranteed and overall standards in place. They've been in place for most utilities, I would say, from 2006. Barbados Water Authority, they are newer to the game. So they can seek compensation under the guaranteed standards of service, where we have a list of standards that minimum standards that they're supposed to comply with. If there's a breach, persons can be compensated under each and every one of those. There are also overall standards that do not attract compensation to the individual consumer, but we track the performance at a national level.
The FTC, as you would have mentioned in your introduction, also has responsibility for fair competition, ensuring that fair competition exists.
Yeah.
And we know the benefits of having healthy competition in an open market, but something that has troubled many sometimes has been the notification of mergers. Now, we know that a lot goes on behind the scenes regarding mergers, but for some consumers, it seems as though it happens suddenly. And a company that they've been loyal to is now being merged with another entity.
Well, we would not offer that disclosure at the beginning of a merger investigation. With mergers, one has to be very cognizant of the market. There will be two entities, or a minimum of two entities, seeking to merge. With that, we have to understand the market share, because they are only required, merger entities are only required to come to the commission if they satisfy a threshold of 40%. Below that, there's no requirement for them to seek approval from the commission. But beyond that, there are possible implications if we were to advise the public too soon.
Explain.
And so it doesn't really mean when we undertake a merger investigation, the first thing we look at is the market. Have they satisfied that threshold? Beyond that, we look at the harms that can possibly take place if a merger takes place. We also look at the remedies because there might also be efficiency gains that can take place. And it's pretty much a balancing act. We have to determine whether the benefits outweigh the risk. That type of determination is made. There is a preliminary investigation. If on assessment of that preliminary investigation, there is no real threat of the competitive nature of the market being compromised, then we would allow the merger to take place. If we have concerns, then we're taking the investigation to another level. At that point, we do a much deeper dive to assess the other players in the market, the specifics of the market, economic circumstances, the financials, and the whole like. So that is intended then to offer us an indication as to what remedies could be put in place to allow for a merger to go ahead, but at the same time ensure that there are no long-lasting negative implications. At times, you can approve a merger with conditions, and that is happening in certain instances. But the critical thing is to ensure that competition is no way compromised. We have an option within the legislation that allows for authorization to be given. So even in some instances when we think that there is harm that can be caused because of the merger of the two entities, there are provisions where it might still be allowed with specific conditions for a specified time. For example, under COVID conditions, it would have been better for some entities, say for example supermarkets and the like, to come together to ensure that provision of goods, there was no scarcity and those types of things. And provisions would be made in certain circumstances like that. So that is really, the authorization is only used in critical situations.
But the FTC does have power to stop a merger from proceeding.
we do have the power to stop a merger, or we can ask entities that went ahead and merged without approval of the commission to unwind. That's a possibility as well.
Has that happened?
Yes. No. If it has happened,
yes.
I do not believe we have had the opportunity to do that as yet.
Explain the practice of anti-competitive agreements.
So anti-competitive agreements, they can present in a number of ways. It can be anti-competitive in terms of restriction of market entry. There could be collusion where persons come together, set a price, set certain conditions. It could be the cost of the purchase of goods or the sale of goods. It could be market allocation. It could be division of the market. It could be division of customers. There are a number of ways in which anti-competitive conduct could take place. And the essential thing is for us to actively monitor the market to ensure that that does not take place, because when that does take place, it really hampers the ability of the end consumer to get the best either price or get the best service or product offering. And that is where we spend much of our time in ensuring that that is not the case here.
When it comes to anti-competitive conduct, is that in terms of, is it widespread on the island?
I would not say that it is widespread. I would say that we are actively engaging persons to ensure, because I mean, it might not be always be something that's very obvious. So that is where the challenge is. We rely largely on businesses or customers to identify suspected cases, and then we investigate. But we keep our eyes open when officers go out into the field. We monitor the press, those types of things, as activities that allow us to gauge the market.
Dr. Adeli Akeshi, we'll take a short break here. Stay with us. You're watching One on One.
All of our emotions, reactions, and behavior start with a thought. I'm Krishnan Hurdle, clinical psychologist and certified life coach. When we are confronted with a situation, the stimuli we receive from the outside is matched up to information, knowledge, and beliefs we have stored in our minds. This creates an emotion, and then a behavioral response follows. The information we have stored as our memories, beliefs, attitudes, and our trauma shape our outlook on situations and our responses to situations. It is therefore necessary to detox, to renew, and to train the mind. Be careful what you put in and pay attention to what comes out. Take control of your mind and take control of your life.
I am Lloyd Gollum, artificial inseminator attached to the Pig Improvement Program in the Ministry of Agriculture. There is a deadly disease lurking on our doorstep. The African swine fever, the ASF, has been detected in the Dominican Republic. This disease is deadly. If that disease strikes, all your pigs can die. For those farmers who usually utilize the traveling mower, both the farmer who receives the traveling mower service and the farmer who operates the traveling mower service must keep their premises clean, disinfect regularly, bathe that animal, keep that mower in a separate pen, if possible downwind from the rest of the herd. When operating the service, take along with you a basin, your brush, and your soap so that you can disinfect before and after. There is a safer alternative. The Pig Improvement Program offers insemination to the general public. And you can get more information about this by simply calling the Ministry of Agriculture 535-5958, 5957, or 5956. When feeding or dealing with your animals, have a set of clothes that is worn only for that purpose. If you're going from your farm to somewhere else, remove those clothes and wash them regularly. Do not feed swill. Swill is all these scraps and pieces of potato peeling that is left over after you prepare your dinner. If that swill contains infected meat, it can bring that disease onto your farm. We have to be very careful. For this disease, there is no cure, there is no vaccine, there is no treatment.
Help us keep African swine fever out of Barbados.
Keep it clean, keep it green.
Barbadians, we invite you to get involved and play your part as we clean and green Barbados. Come into your community with media launches, bulk waste collection exercises, community engagement sessions, and giveaways. Get on board. Let's keep Barbados clean and green.
Beautiful, beautiful Barbados.
Hello, I'm Dr. Ingrid Burrows, and I'm going to give you some tips on managing your hypertension. The first thing you should do is to decrease your salt intake. You should keep your salt intake to less than 1 gram a day. This is equivalent to about 1 teaspoon of salt every day. Another thing you should do is to ensure that you're getting enough physical activity. You should aim for 150 minutes of aerobic exercise every week of moderate intensity. For example, brisk walking, light jogging, swimming, or running. This equates to half an hour of exercise 5 days a week. You also want to increase your intake of fresh fruits and vegetables. It is advised that you eat 5 servings of fruit and vegetable every day. And the last thing you can do is monitor your blood pressure at home with a digital machine. This is very important as some patients have elevated blood pressures while in the doctor's office while having normal blood pressures at home. This is called white coat hypertension. Also, if you're taking medication for your hypertension and you notice any changes in your blood pressure, you can call your doctor and he or she can adjust your medications to suit. If your readings are too high or too low, you can inform your doctor and he or she can adjust your medications appropriately. I hope these tips have been helpful.
When does a mental health issue become a problem? When should you reach out for help? I'm Krishnan Hurdle, clinical psychologist and certified life coach. Mental health issues interrupt a person's daily functions. An issue becomes a disorder when a person isn't able to carry out their everyday activities like household duties, personal upkeep and hygiene, or interferes with their ability to function socially, to interact with others inside the household, or interferes with their ability to function on the job or carry out other activities. If a person finds themselves needing to self-isolate, losing touch with reality, or having an impaired ability to think, reason, or function, and if this occurs over a period of days, weeks, or months, then it is time that they reach out for help.
And welcome back. We're talking to the CEO of the FTC, Dr. Marsha Atherley Akechi. Dr. Atherley Akechi, before the break, we discussed utility regulation and fair competition. But one of the things the FTC is known for is consumer protection. Now, how big of an issue is false advertising?
It can be an issue. I would not say it is a major issue in Barbados at this time. But there are certain sectors that we are particularly interested in, and we have sought to provide that training and awareness to suppliers. I would not necessarily want to name them at this point, but there are certain segments, particularly in the COVID period, where we saw advertising that was not what we would want it to be and that appeared to contravene the Consumer Protection Act.
No, you don't want to name them, but can you at least tell us the segment?
So, pharmaceuticals, that was one segment, one sector that we were particularly concerned about.
Explain. Why?
Because you're advertising, or persons are advertising products that are expected to offer certain results, but it is not grounded in science. Customers have the expectation, and a reasonable expectation, that when they buy a product that has been advertised to offer X, Y, or Z, that it does in fact offers X, Y, and Z.
You said segments, but you just said pharmaceuticals, so there are others.
Well, that is definitely one.
Okay, so you can't share the others with us.
I just use that as an example.
Okay, I'll take that. No, we still see the signs of no exchange, no refund in 2022.
That is a challenge. That is a challenge for us. We go out into the field from time to time, and where we see those signs up, we advise the owners that those signs are illegal. What I must point out, though, is that when there's a no refund is subjective in a sense, in that a customer buying a product, going home and recognizing, okay, I don't like this color anymore, or I don't like, the size is too small, or whatever. Under those circumstances, the business is not obligated to refund or to exchange the product. If you go down the road and you see the same product at a different price, the business is not obligated to exchange or to refund. It is obligated to do so if the product is defective or is not fit for purpose, only in those circumstances. But that blanket statement really is not supported by legislation.
How many complaints does the FTC receive?
At the end of the financial year, March 31st, we registered a total of 2,452 customer queries. And it will vary depending on the time of year. You will get more around like Christmas time, back to school, high commercial activity periods. Again, In the midst of COVID, we would have seen a reduction in complaints, obviously because the commercial activity was considerably reduced. Our concern, though, at this point is moving toward online services because we recognize that legislation necessarily does not speak to that in its full state. Legislation obviously oftentimes lags behind the technology, and that is something that we are looking at reviewing so that we can advocate for an amendment in legislation to allow it to be fit for purpose. Beyond that, we've taken the opportunity to do a number of things. One, develop a retail business guide for the sector, and is largely focused at businesses where we seek to educate them in very simple terms as to what their responsibilities are, what their rights are within the remit of the legislation. That allows them to better service their customers, reduce incidents of complaints, and therefore it speaks overall to the welfare, improved welfare of consumers.
Regarding the incidents of complaints, though, I know you said for the last financial year you had just over 2,400. How does this measure up to previous years? Is this high? Does it fall within the normal range?
I would say it varies from year to year, depending on what is on the table. During the COVID period, there would have been less. At times, we can see an increase, but it really varies. It really varies significantly.
Staying on the issue of complaints, so your officers go into the field. First of all, the FTC receives the complaints, and there's a particular business perhaps that, let's say, 30 or 40 customers keep complaining about. You go out, they're in complete breach of the Fair Competition or Consumer Protection Act. What happens next?
In a case such as that, we first start by seeking to counsel the business owners, pointing out the areas where there's been a breach, indicating whether we believe it is a persistent situation. But we've moved from a stance of education and public awareness to one of enforcement, and that has been signaled across all three divisions of the Commission in recent time. So, for example, in consumer protection, we have moved to do undertakings. And an undertaking is essentially an agreement between the entity that has breached the Consumer Protection Act and the Commission for systems and policies and procedures to be put in place to ensure that those breaches do not continue going forward. So there will be specific clauses which the entity would have to institute in their daily operations to ensure that they become compliant going forward. The other element of that is monitoring and reporting. They will be required to report to the Commission on a quarterly or a monthly basis, depending on the severity of the issue, whether we believe that there needs to be very tight scrutiny brought to bear on the situation or not. And we will do that. And then there's also us actively monitoring. And usually an undertaking can be for an indeterminable period of time. The one that we undertook recently is expected to be for 2 years. So that will allow us really to get an assessment as to how the corrective measures that we put in place, how those are operating. If at any point we believe that amendment needs to be made, then that is possible as well. But we've not taken persons to the law court. That is an avenue that we can pursue, but that has not happened to date. That is not to say that it will not happen, because we've signaled enforcement, and that, to my mind, is the ultimate stage of enforcement. But if we can go the route of curbing that behavior, bringing about that change sooner rather than later, that's the route we'll opt to take. Because going the route of the law courts, that is time consuming as well as costly on both parties.
And do you see a pattern in terms of customers complaining for the same business over a period of time?
In some instances, yes, definitely. They would complain largely relates to service quality issues, in some instances price and the movement of prices within a relatively short period of time. So those types are the major types of complaints that we see.
And consumers have a lot more rights than they know. What is the FTC doing to help educate the public about their rights?
We engage with consumers regularly. In March, there was a business fair facilitated by the Ministry of Energy and Business. We had a booth at that particular one. There was another one in Hoyts Village was at the end of March or June. We participate in that as well. Beyond that, we engage on social media regularly. We do brass tacks as is necessary. But we always invite persons to come into the commission or call into the commission and have any issues that they have resolved as best we can. But beyond that, we tend, outside of a COVID environment, we tend to go into the communities, go into places like Bridgetown, go to the malls on a quarterly basis and engage directly with customers. We also have a customer hotline that persons can reach us through.
No, just for the sake of the public, you mentioned that you can come to the commission. Do I need to set up an appointment or just turn up?
At this point, at this stage of COVID, you can just come to the commission.
Okay.
Yes.
Now, one of the things the FTC is also focusing on is the mobile code. Tell me about the mobile code. What is it? How does it work? What are you doing?
So the mobile telecommunications code, that is a voluntary program with the two major telecoms providers that sets minimum standards of service for those entities. It speaks to advertising, for example, ensuring that what is being offered is what the customer actually gets. Say, for example, when you advertise something as being free, it must indeed be free. It goes beyond that to look at things like contracts, clarity of contracts. We know in some instances the telecoms providers usually communicate over the telephone and settle on certain packages. We want them to follow up with something in writing so that it's clear, both parties are clear as to what is being contracted for. Things like roaming charges, data packages, those types of things are being addressed in that contract.
Now, you mentioned Digicel, but Digicel is not one of the utility companies you regulate. And why is that?
The commission was established in 2001. That was prior to the liberalization of the telecoms market. At that time, the monopoly player was Cable and Wireless Barbados Limited. So in the schedule of services, Cable and Wireless is listed. Again, regulation really only takes effect when there is a void in terms of competition. So in that instant, with the monopoly player, it was deemed that regulation was necessary. And you regulate the monopoly provider, that being Cable and Wireless Barbados Limited. The schedule that lists the services has not been amended. And Cable and Wireless still has the dominant share in the market. So that is why it is not regulated. But issues relating to Digicel can be dealt with through consumer protection and not necessarily utility regulation. And that's how we treat to those types of issues.
I heard you mention fees. I heard you mention contracts. Barbadians have complained bitterly for several years about fees from the various commercial banks. We know that the Central Bank of Barbados is the regulator for the banks. However, when it comes to consumer protection, what is the FTC doing to ensure that if a consumer comes to you and they have a particular issue with the bank, they didn't understand the contract, for instance, or they think that they're being overcharged, what are you doing to assist that consumer?
We have indeed received some of those types of complaints. The position taken by the Commission in recent time is that it will review the banking contracts. Banking contracts relating to credit cards, relating to mortgages, those types of things. The assessment really is to look at the provisions of the contracts. One, to ensure that it is in a font and is in a format that the consumers can easily read in the first instance. Because if you're presented with a contract that is in very, very fine print and it's all over the place, then persons are not inclined to read it. And just as a result of that, they are at a disadvantage. Secondly, we want to ensure that the provisions of the contract, the clauses in the contract, comply with all the requirements of the Consumer Protection Act. Where there are challenges with that, we point out those to the various banks, have the conversations as to why they present a challenge, and seek to have those rectified. We are in the process of doing that, and I believe we are pretty much at the latter stages and having those types of clauses, those clauses that are offensive, remedied.
No, your mission statement is behind you. To be a transparent and accountable agency providing professional services to those whom we serve, thereby safeguarding the interests of consumers, promoting and encouraging fair competition, and ensuring efficient regulated services. However, as CEO of the FTC, how do you respond to criticism from consumers that you are not doing enough, and you being the commission to protect their interests?
I think, and I will take this, I think we do not do enough in terms of engaging consumers as to what exactly we do. That is part of the challenge. From time to time, you will hear, we will go out, face the public, and you will hear, oh, what do you do? I've never heard of you. That is a challenge because we've been in existence for 21 years. And if we are still getting that, that means something is wrong with our communications plan. We have to move to the point where we are widely known. They understand exactly what we do and what we do not do. I believe that the public has a perception, one, that the Fair Trading Commission as a whole body is a consumer protection agency. It is not. It has a consumer protection arm, it has a utility regulation arm, and a fair competition arm. When it comes to, say, for example, utilities, that is the perspective that customers believe is the case. But what I would want to impress upon persons is that on the utility regulation, it is a balancing act in that we have to safeguard the interests of consumers, but at the same time, we have to ensure that the utility is at a point where it can provide that service. So that is very much of a delicate balancing act that has to take place. In the rate hearing, you will hear a lot of talk about rate base, a lot of talk about revenue requirement, a lot of talk about rate of return. The utility will ask for a rate of return, is asking for a rate of return of about 8-point-something%. The onus of the commission is not to guarantee that rate of return. And I want to stress that. It is not to guarantee that rate of return. It is to provide an opportunity for the utility to get a reasonable rate of return. A reasonable rate of return is not necessarily what they've asked for. The regulator has to do its due diligence in understanding the financials of the utility, understand the capital outlay that it has to undertake, and therefore come up with a rate of return that will offer the opportunity for them to gain, for them to reach that level where they're viable. So it's nothing more. It's very much a balancing act.
So you do not take the criticism that you're leaning towards the side of the companies or the utility companies?
Absolutely not. That is one criticism that is not founded in fact. The utility regulation department is set up such that the analysis has to go into it. We focus our work very much on the empirical data that undergirds everything that we do, as well as the legislation. Those two things are the fundamentals in terms of how we go forward with any decision. The last rate application, The utility asked for 10.75% as a rate of return. It was given 10%. In terms of standards of service on utility regulation, we consistently seek improvements in standards of service, tightening of the targets, for example, so as to afford the customer a better experience. It is very much about balancing, it's about taking not only the customer forward, but the utility forward as well. Because all the utilities, whether it's Light and Power, Barbados Water Authority, they're offering a service to the public. And as such, they ought to be proper corporate citizens. So if I were to sum up the work of the Commission as a whole, it would be sustainable development, because all three arms of the Commission are intricately intertwined to be able to deliver on the mandate of the Commission. And that, at the end of the day, can be summed up as sustainable development. We need consumers, we need well-operating markets, competitive markets, we need proper functioning utilities, delivering service on time, good quality for us in all the spheres of economic activity and personal endeavors to be able to operate properly.
And following on from those points, for several years you were Director of Utility Regulation. Now, as a Chief Executive Officer of the FDC, what is your vision for the Commission?
That is a very good question. My vision is to continue to ensure that we are on the cutting edge in what we do. It is about ensuring that staff, first and foremost, because those are the internal constituents, that they have the tools to do the job necessary, that the legislation is supportive and practical. Our legislation is somewhat dated, and we need to be able to offer those revisions to allow us to do what we ought to be doing. Beyond that, it is about using empirical data to substantiate our decision. When a decision is made and we can stand by that decision, given the information that we have at the particular time, I am quite comfortable. That is what we seek to do. Our board, has a very diverse background. We have lawyers, we have economists, we have accountants, we have business persons on the board. So they offer a different perspective than what an analyst or economist within the Commission working would offer. That allows us to have a holistic view, understanding the pulse of the community, and being able to deliver on that. But at the end of the day, it is about ensuring that we deliver to the people of Barbados in a consistent way so that there's certainty as to how we regulate. We want to provide that certainty to customers. We want to provide that certainty to investors as well. We want to provide that certainty to businesses. That is my objective.
Well, we appreciate you sitting down and explaining as much as you have with us today. We know that you're very busy, you and your team here at the FDC. Thank you so much for talking to us.
Thank you very much for allowing me to present the Commission to the public of Barbados.
You are most welcome. Thank you once again. That was the Chief Executive Officer of the Fair Trading Commission, Dr. Marsha Atherley Akechi. I am Lisa Lord. You are watching One on One. Do have yourself a wonderful evening.